I'm not a lawyer. I'm discussing things that are said on the internet about law that are demonstratively false and are easily checked by the common ordinary person. Warning, some people will post something that is not true for several reasons, but most importantly because they don't know that. Next, one of the exploitations that's done on the internet is finding people who are stubborn enough that they'll never admit when they're wrong when it's a petty thing. Because they know that on the internet, anything, even if it's life-threatening, suddenly becomes very petty to the person who's lying or stating it because, oh, I'm behind a keyboard, it doesn't hurt me. And, more importantly, people who wish to create rhetoric or propaganda will exploit people who are found to be stubborn and never admit when they're wrong and get them to amplify or signal boost, like Twitter, any bullshit story they want to come up with, especially if they can do it to harm that person's country. There's a terrible irony in getting some of you to say things that can cause you to be harmed or your family or friends. The half-truth, out of context, quote, from a history of a word within the definition of the word in a dictionary. Current and old Black's Law dictionary and other dictionaries have a definition for a word. The word, like any dictionary would have, will include its history, including previous meanings for the word that no longer apply, or previous definitions that never did apply to that word, but applied to another word that was the root or origin for it. Looking up the letter A, you find out it comes from aleph, which is a symbol for an ox. That does not mean that when I type out a cat, that I'm saying ox cat. These older and current books for a dictionary, specifically Black's Law, includes the following definition for court, and it's the definition, and it's been used for a very long time. An organ of the government belonging to the judicial department, or in the United States, the judicial branch of the government. We have a checks and balances 3-branch system, approximately. The court's function is the application of the laws to controversies brought before it and application of laws to the public administration of justice. Now, if you're not aware of what I just did, read below me, and you'll see that it says application of laws to controversies brought before it and the public administration of justice. Now, that's not ambiguous, but it's an example of a parenthetical or compressed sentence, A sub 1 or sub 2. This is something that's favored by the legal system because it takes up less paper on a sheet, and it also makes it kind of hard to read so that you have to hire a lawyer. Let's just admit that. But the fact is there's been a major push because of the internet and its binariness of not really needing to take up more space on a sheet. You can just make it take up more space in a file. It doesn't weigh anymore. To write out that compressed version to application of laws to controversies brought before it and application of laws to the public administration of justice. This makes it harder or impossible to make an ambiguous statement and therefore need a lawyer. But that's just a conspiracy theory. Now, also included in this is a history lesson that includes other definitions for the word court, including an international law definition that was used a long time ago or may currently be used for very flowery documents between countries that don't speak the same language or even the language in the document. I would call this the international law definition for court, or globalism one, which is the contention people are making that because it's in there, it excludes the obvious definition of what the court is, the thing you and I know about, and makes it into a globalist statement. The person and suit of the sovereign. Also, the place where the sovereign sojourns with his regal retinue, wherever they may be. Wherever the king goes is court. And it's the coat, or the appearance of court, is the same as the king and queen, or the appearance of the king's court is the court. Retinue means the entourage, or the regalia, and all that kind of stuff. That's the definition in international law of a vague assertion that a court, primary one they're using here, refers to the king's court. It has nothing to do with the court in the United States because we don't recognize a king. But it's this word sovereign, and no, it doesn't mean that. Also included is the English government being spoken of in diplomacy as the Court of St. James because the Palace of St. James is the official palace for it. In legislation, a legislative assembly, parliament, called a court. And it can be called, I'm going to read it their way, court of king, nobility, and commons assembled. Or the court of the king, or the court of nobility, or the court of commons assembled. Which is it? That's a compound sentence. It can be taken either way. That meaning of the word, which is just a parliament, has been retained in the titles of some deliberative bodies, but it's not given an example of it, such as the General Court of Massachusetts. This is about the history lesson of the word itself. It could all go all the way back in time to refer to a Hebrew word for potato, or ox, or something like that, having a meaning. Yeah, that's the Aleph thing. But that doesn't mean a 3,000, a 1,000-year-old definition applies anymore. Nor does international law definitions apply to the U.S. government. Just because it's in Black's Law Dictionary doesn't mean it's the current rule. It just means it's an old definition for a word. Public domain, free online Black's Law dictionaries are available from 2nd edition 1910 and also 1st edition 1891, which is much more antiquated and actually has spelling errors. So which one do you cite when you look things up? Hidden laws. UCC 1-130 or 103.6. There is no .6, most likely. Your common law Bill of Rights recourse. It's a hoax. Uniform Commercial Code, UCC. It's complementary to what's commonly called common law, where it remains in force. Some common law isn't in force because we have more formal laws and we don't cite common law. You don't like that? I don't care. Except where displaced by Uniform Commercial Code, within it says that it can displace common law. Again, someone in the keyboard warriors slapping away at the comments. I'd make a joke, but you already made it. Uniform Commercial Code must be liberally construed or must be liberally assumed or understood and applied to promote its purpose and policies that underlie it. What does that translate to? Uniform Commercial Code, or UCC, must be thought of based on its intent, not just what it's written out as. Oh, but let's ignore that when you're citing this explanation here. Number 1, to simplify and clarify and modernize the law governing commercial transactions. Translation, removing old English and Latinistic stuff to make it in plain English right now for commercial transactions so that ordinary people don't have to have a lawyer, so we don't have problems. Next one, to permit the continued expansion of commercial practices through the following systems. Our customs in the country we have. The usage we do. Agreements of the parties. And also to make uniform law among the various jurisdictions. This includes city, county, states, and agreements between them. If they find a problem between Washington and Oregon and solve it by making a UCC temporary example law, it gets spread throughout the entire United States because it solves a problem that people haven't even run into yet, before they even run into it. UCC is pretty deep, and people misinterpret it because this is done as a multi-layer thing. And now I'm going to read B. It goes 1, 2, 3, and then it goes to B. There isn't any A listed, but it's supposed to be referred to as A by custom, but it's not explicitly said, but it's implicit. Here we go. What does B say? I'm going to read this verbatim, and I'm not going to try to translate it. This is an example of what they're trying to fix within the rule about how they're trying to simplify things, amazingly enough. Unless displaced by particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to correct or to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating causes supplement its provisions. Yes, that is understandable, but barely. No, I'm not going to go through it. There isn't any Part 6, and people cite this as UCC 1-103.6. There isn't any .6. There may have been at one time or another, but they don't cite what they're referring to. And they just say it's a magic wand, just apply it, and then you read it and they don't tell you what it is. Or they have a video saying what it does, and they don't even show it on screen. Or they quote something else. Then we have 26 U.S.C. Section 6331A. Yes, it's A. Actually, there is an A to this. The rhetoric of professing a belief that any reference to a kind of person or group excludes all other kinds involved, or in this case, taxpayers. One kind of taxpayer, if you mention it, well, it excludes that rule from ever applying to anybody. That's called the exclusive versus inclusive, logic fallacy. Reading and restating this section of USC selectively, I'm not going to do that. I'm going to read it to you. Now, this is me reinterpolating it. You get to critique my rewrite of this, rhyme remix of these two sentences, and there is just two, and show me where I'm wrong. Not that you have to prove me wrong. You have to find out what I did wrong, because I did something wrong here, and I know I did. But I'm going to read it to you because this is clearing it up more. It is lawful for the Secretary, IRS or whatever, to collect and demand any tax and the expenses collecting it from anyone through levy upon all property and rights to property belonging to anyone who neglects or refuses to pay a tax within 10 days after the levy notice. That's sentence number 1. It is lawful for them to do this if you refuse to pay your taxes or fail to do so. After they give you a 10-day notice, they can put a levy or lien or whatever against your property or your right to have control over it to force you to pay or to actually just threaten to liquidate. But they made another rule right after it. This one is, it's lawful for the Secretary to collect and demand any tax plus expenses from accrued salary or wages of any elected official, officer, employee, or anything else of any agency or instrumentality of the U.S. government and the District of Columbia. Does that mean only if you're in the District of Columbia? By serving a notice of levy upon the employer of anyone who neglects to refuse to pay taxes. If you get a job with the U.S. government, there's a part in there where they warn you that instead of sending you a bill or taking you to court, they'll just leave you employed and take all your back taxes out because they assume you made a mistake, and you'll just pay it off the next year because they'll start taxing you every month on your paycheck. They just garnish you. This is a special provision for U.S. government employees of any kind to be taxed. That doesn't mean that the previous statement that took up every human being in the United States and anybody else involved and who knows what else, it doesn't make them not allowed to do it. This is not a rule, these two sentences. Don't make it to where only government employees and only in Washington, D.C. can be taxed or be forced to pay tax. That's not what it means. The first sentence, by referring to all persons liable to pay any tax and all property and rights to property, is all-inclusive and excludes no one. The second sentence states how levies on salaries or wages, garnishment, of federal officers or employees may or can be made through their boss, through their business, through the government. And again, I've signed a piece of paper like this before that said that I would be subject to garnishment if I didn't pay taxes. They just make you pay the taxes against your will. If you want to earn a living through the U.S. government, you cannot be defaulting on what you owe in taxes. You can't. The work lacks the specific word includes. Two sentences. Sentence 2 limits none of the scope of the sentence previously, explicitly or implicitly. The work lacks that word, that's all. Sentence 1 authorizes a levy on all wages to all entities, both public, private, individual, and group. Sentence 2 extends sentence 1. Sentence 2 does not nullify any part of sentence 1. That's all. So let's review. Black's Law Dictionary, when people quote the history of a word rather than its definition, that's not its definition. Even if it's a previous definition that is no longer used and it's an international definition, that doesn't have anything to do with the United States. Quoting the King's Law doesn't work if we don't acknowledge or pay attention to the King of England or anybody else. And demanding we listen to someone quote this ironically by saying that it authorized them to have autocratic control over my life is an example of somebody projecting their will to be the Dark Lord of something dark side. Misinterpreting or misreading laws is a criminal behavior, in my opinion, but it's not punished enough. And quoting USC or the other things inaccurately, or making up references like .6 or .a when it doesn't apply, or ignoring it when it does, is an example of someone trying to make sure you can't look up something to find out they're bullshitting you.